Hi, everyone. Happy Friday afternoon. Welcome to another episode of myvideolawyer.com. Today, we're talking criminal defense. We're talking about getting answers to questions such as if you're walking down the street, you haven't done anything wrong, and a police officer comes up and stops you and starts asking you questions and starts asking if he can have you empty your pockets in front of him. What's your response? What should you do? We've got a lot of questions submitted to us today, criminal law, criminal procedure related questions, and I've got just the guy here today to answer these questions for you. His name is Mr. Johnnie Finch. Johnny's from North Carolina. He's a criminal defense attorney. And Johnny, welcome to the show today.
Thanks, Mitch. I'm glad to be here.
We're glad you're here. And we've got a bunch of people that have submitted questions. I want to jump right into the show, Johnny, and hopefully you can shed some light and help our viewers, both during the live and recorded show, with understanding what their constitutional rights are when it comes to criminal law. By the way, everyone, before we get started, Johnny and I are great lawyers, but guess what? We're not your lawyers. And so we have to be careful about that pursuant to state bar rules. We can't give out legal advice. We can't share legal opinions, but what we are going to be doing today is giving you good, specific, general answers and responses to your questions and hopefully get you going in the right direction. If you have a question for Johnny after the show, you can reach him using the above links. His law firm is guntherlaw.com, and you can connect with Mr. Finch on Twitter, and I want to hear you say it. What's your Twitter handle, Johnny?
Cool Relax. COOLRELAXED. Cool Relax.
I got to tell you guys, when you're in court, especially in a criminal trial, this is the kind of guy you want sitting next to you protecting your rights. Somebody that knows what he's doing and somebody who is cool, relaxed. Johnny, let's jump into the first question. And it's been asked in more than one way by different people throughout the course of the week. By the way, everybody, tweet out right now, whether you're watching live or recorded using the buttons next to Johnny. Tweet out the show on Facebook, Twitter, Google+, LinkedIn. Share your questions in the chat. Go to myvideolawyer.com to submit questions for future shows and to watch past episodes. Question of the day, Johnny, is what's the biggest mistake that you see clients make when interacting with police officers?
By far, the number one answer is being belligerent or catching an attitude with law enforcement or even being physical. You got to realize when you're out there, it's the cops or law enforcement, as they like to be called, it's their turf. Realize if they're having a bad day and you're having a bad day, your day is going to be worse. Keep your voice down, submit, don't make any fast movements, take the low road. At all costs, ignore engaging law enforcement because they have weapons, they have batons, guns, and mace. And if you pull yours out, it's going to be a bad day. If there's any recourse, I always say, get home, call someone, call a lawyer, talk about your options. If you feel like your rights have been infringed upon, but do not get belligerent with law enforcement.
Just be smart about it, right? You want to be smart about it. You never know what the police officer is stopping you for. They may be stopping you to harass you. They may be stopping you to intimidate you. That's been on the news a lot lately, okay? We don't want anybody getting hurt, so we want you to be smart about this. But they may be actually conducting a good faith investigation about something that happened that you're not even aware of. And by the way, I'm a civil lawyer. I handle civil cases, catastrophic injury and wrongful death. Criminal law is not my bag. If you have a criminal law case in North Carolina, contact Johnny. If you have a criminal law case right now or question and you're in a different state, contact a qualified lawyer to answer your questions and to get you going into the right direction and to protect your constitutional rights. Let's get that clear right now. But Johnny, good advice. And along those same lines, we have constitutional rights. And those constitutional rights shouldn't be infringed. So you're stopped. Let's say you're walking down the street and you haven't done anything wrong and you're stopped, and that police officer starts asking you questions and starts demanding that you do things. What should you do next?
My take is always this. Look at your circumstances. If you're walking down the street and you see a law enforcement officer and he appears to be talking with different individuals, asking different individuals questions, If he asks your name, I always say, I will always tell him what my name is, and I'll show him my ID. That is how I'm willing to submit to show that I'm not trying to do anything adverse to what he's doing, and if he could be possibly looking for someone that could harm me. However, if you choose not to give him your information, at that particular point in time, you have not violated the law. If he says stop, you're under arrest. At that particular time, you need to stop. But until he says you're under arrest, you can't walk, I suggest giving him your ID and continuing on about your day. You don't want to frustrate the situation. It could be a mistaken identity or any of those things. As I said, he may be having a bad day. But by law, you don't have to stop unless he says, hey, stop, you're under arrest.
Couple of terms. An interrogation, an arrest, you're walking down the street, you're having a conversation with a police officer, you're answering his questions. Can you share with the viewers, both live and on the recorded show, what's the difference between an interrogation and an arrest? What do people need to be aware of?
An interrogation interrogation is anytime law enforcement is asking you questions in furtherance of their investigation. So if he stops you on the side of the road, he says, hey, you know anything about this? That's an interrogation. If he comes to your house, knocks on the door, hey, can I ask you a question? You say yes, that's an interrogation. If he goes and comes to your house and asks you questions about your neighbor, that's an interrogation. The difference with an arrest is you are the one that he believes has more than likely than not committed a crime. And at that point, you'll be processed. He'll say you're under arrest. He'll take you downtown and put you in front of a magistrate. There's something also called a custodial arrest. That's where an officer may be asking you questions, and the way you find out if you're under custodial arrest is by saying, am I free to leave? If he suggests, no, you're not free to leave, at that particular time, you're under custodial arrest, and what I suggest is asking for your attorney.
When it comes to somebody asking for a lawyer, asking for their attorney, what advice do you have for our viewers as to when that request, when that demand should be made? What are some of the factors people should be aware of or take into consideration before formally requesting an attorney, if there are any?
Well, a good black and white rule is, unless you call law enforcement for a particular reason because you need help, I would cut down as much interaction as possible. So, if you're stopped on the side of the road in your car, given your license and registration, if he asks you, well, where are you coming from tonight, or where are you going? Sir, I've given you my license and registration. Am I free to leave now? The less interaction, the better. You're minding your business. You're a lawful citizen. You don't have anything to hide. However, the only thing that you owe him is your license and registration because you are on a state road or a United States road, so that is a privilege. But other than my license and registration, once they check out, sir, am I free to leave? If not, can I call my attorney?
I don't want to put you on the spot, and I know each state is different, but what if you're on private property? What if I'm standing on somebody's front lawn on private property, and the same thing happens? I'm approached by a police officer who starts, asking me a bunch of questions. At what, am I still required to show my ID? Can I immediately ask for an attorney? How do you handle things like that in North Carolina?
Well, if it's considered private property, if there's a fence up and for some reason the law enforcement officer has to come inside the fence, usually they'll have a search warrant or something that's considered within the curtilage of the house. So if he knocks on the door and I guess he wants to come in through the fence, you can say, no, you're not allowed, considering how far it is away from the house. I would suggest, sir, am I under arrest? Otherwise, I don't have anything to say to you. Keep in mind, it's not so much what is legal from the law enforcement opinion, but it's what you consent for him to do. So if you say, come on in, I don't mind you searching my house or you searching my person, that's the right that you give up. Don't think about what he can do. Think about what you can do. And if you're in your house, you are fine.
Okay. And people aren't required to give up their constitutional rights. In other words, would you agree that it might be the more prudent way to handle situations would be to let the officer know you've complied the way he wants you to? You have nothing else to say, and if he has any other questions, you'd like him to you'd like to have a lawyer represent you. That's perfectly okay, correct?
That is the best way to handle it in the most calm voice you can possibly say it in.
You mentioned search warrant, and one of the questions that we were asked more than once, I think the questions came from California, but I think it applies to everybody across the country, and it has to do with if I'm driving my car and I didn't do anything wrong and I'm pulled over, and the police officer during the interaction asks if he or she can search my vehicle. What would be the best way for me to respond? What would be the best way for me to handle that particular situation? Maybe you could discuss in your answer what a citizen's rights generally are across the country and how a search warrant or reasonable cause might come into play during a search request.
So, all of us have certain constitutional rights to privacy. When you're driving in your car, it's your car, you have a right to privacy within your car. The most protective right, is, of course, is in your house. Now, while you're driving down the street, the officer can only stop you with reasonable suspicion to believe that you've committed some type of infraction or criminal act. Or if it's a checkpoint, what they're doing is they're stopping every car in a like fashion and not randomly selecting cars. What I would suggest is this. If he stops you for a speeding ticket, for example, and he gives you your speeding ticket, at that particular point in time, sir, thank you, you've given my speeding ticket, am I free to leave? If he asks for consent to search at any time, whether it's a speeding ticket, where you're on the side of the road, where you're in your house, no, that's your right. That is your constitutional right to not consent to a search because you don't know what he's looking for. You don't know what's happened that day. I always say that we have great law enforcement officers here in North Carolina, and I'm sure you have them in California and all across America. However, if you give up your right and let the officer search, he could plant something in your car. He could have a partner who's looking to move up in the ranks. And I have seen this before where officers were looking to come up and get promoted to different positions, and the way they thought to do that was to get drug busts. Well, what they would do is they would go and pretty much profile individuals who look like they may be dealing in drugs or having a criminal record with drugs before. Ask to search. The person says, well, I don't have anything in search. And then they throw something in the car. Now, that is so hard to prove in court. How are you going to prove that a guy who has a record for drugs previously didn't have drugs in his car that day? But you consent it to the search. Never, ever, ever consent to a search.
I'm going to ask you a follow-up question, and it ties in with a question that more than one person's asked, and it has to do with, as a criminal defense attorney, Johnny, how do you feel about smartphones, cameras, video cameras being used by people at scenes of incidents, being used by people that are being either arrested by a police officer, and cameras being worn by police officers? What are your thoughts on that? And I don't want to throw too much at you at once, but in that scenario where you are pulled over and you didn't do anything wrong, do you have the right to pull out your smartphone and start videotaping exactly what's going on while you're being questioned, maybe at 10 o'clock at night on a dark road with nobody else around?
Well, Mitch, I'm going to tell you, I'm acting in my best behavior right now because I'm on camera. I'm not acting up. And my answer to that is this. I love camera. I love recordings. I love audio recordings because it's a check for everyone. I do a lot of DWI work in North Carolina, and what you see a lot of times is there's your FSTs. We've all seen them. There's the pen test where you go here, you come up, and they say, oh, your head moved. Or they ask you to do, law enforcement will ask you to do the walk and turn. Or you step one off. Or one leg stand. These are what the officer will testify to if we go to trial. And what we have is his memory and his notes on that day from a year and a half later. Does he remember what happened that day? Probably not. He has notes on what happened. But if we have an audio or video recording of what actually happened, we don't have to rely on the human officer's memory or his notes. What we have is a system where we can say, well, that didn't look too bad. He didn't look like he walked off. And we can argue this in court. But what we have right now is just his memory. So Any audio or recording is always favorable, I say, for everyone. If the officer wants to say that the person that he stopped made a fast move, we can see that fast move that he made. So it protects the people as well as law enforcement when you have a camera there. And I believe at this point it's pretty much federally been recognized that you can have a camera and audio to record if you're stopped by law enforcement, as long as it does not impede the investigation. So if the officer asks you a question and you're recording, that's fine. Now, I wouldn't put it in front of his face because that'll make him angry, number one, when we talked about being respectful. Or I wouldn't, if an officer was arresting someone, I wouldn't go and, impede him to try to record him because you'll probably get slammed to the ground. My whole point is do it in a respectful manner and everything should be fine. Now, if he comes and he slams your phone down, that's another issue, but it's on the phone. I mean, I would not give your phone up. I would keep your phone. Just do it in a respectful manner, and we should be okay.
I'll tell you what, if I was in a situation where an officer grabbed my phone and threw it to the ground and stepped on it, if I could get out of that situation in one piece and realize the only damage today was to the phone that can be replaced, that probably gives you a pretty good idea of what kind of day that police officer's having, right? It's a good barometer to give you an idea of who you're talking with. What about using, and by the way, I want to say hi to Steve Gomez, a friend of mine that's watching the show right now, a good buddy here in Orange County, California. Hi, Steve. How you doing? What about people using smartphones to videotape incidents that we've seen on the TV over the last couple of months? I mean, some real tragic events where the police have said one thing went down, but the videotape clearly shows something quite different went down. Is it legal for people to videotape? If I walk up and I see a police officer harassing or arresting somebody, can I videotape that from a distance? And if so, what things should I keep in mind while I'm doing that?
It's absolutely the same principle as if a law enforcement officer were recording you. We as citizens have the right to whatever public space that we have. So as long as you're not impending on his investigation, it is your right to have a camera. He may come and say, hey, what are you doing? Put that down. He can say put that down because, again, law enforcement officers can say pretty much whatever they want. Now, coming snatching your phone is something different. But for your protection, for the law enforcement officers' protection, I would say keep the phone because at the end of the day, when you get to court, everybody kind of forgets what's going on. The client is not going to remember. Law enforcement is not going to remember. But if you have a camera there, once you take it to your attorney and say, I have this videotape, what I'm going to do is I'm going to call the DA, the prosecutor, and I say, hey, guys, I have a tape of this. Let's talk about it, and maybe we don't have to go to trial. These are all things that can be used to help everybody. And like I said before, if I'm on camera, I'm acting a lot better than I would if I wasn't.
Keeps everybody honest, doesn't it?
Oh, yeah.
Let's change directions real quick. And by the way, everyone, I'm on the Spreecast with Mr. Johnnie Finch. Johnny's a criminal defense attorney out of North Carolina, and he's kind enough to take time out of his day to answer some of our questions today. Johnny, one of our viewers emailed me the question. Let me read it to you so I don't mess it up. My lawyer convinced me to enter a guilty plea, and I did. Now, before sentencing next week, I want to change my plea to not guilty. I didn't do what I was charged with and was simply trying to save money and time by not fighting the charges. Can I still do this? Will the judge get upset if I do this? Will the prosecution get upset? Will it result in more jail time if I'm ultimately found guilty at trial? What are the ramifications, maybe in North Carolina, and if you know across the country, once you enter a guilty plea, can you change it before sentencing, or is it a done deal?
First, yes, you're going to piss the judge off. Yes, you're going to piss the DA off, and you're probably going to piss your lawyer off. What I suggest is this, and in North Carolina you have a form. There's a big form, and when you enter a plea, it's not just do you plead guilty, it's do you plead guilty? Do you understand what you're doing? Do you understand you're giving up your rights to a jury trial? Do you understand you're giving up your rights to appeal? And then you swear in court and then sign an affidavit that says that, hey, this is it. So it's not likely that the judge is going to let you come back and say, no, I don't want to do it. it's likely that he'll go ahead and sentence you that day. Now there'll be maybe some type of form of relief afterwards if you feel as though there was something that wasn't addressed properly. That is your right. But as far as in North Carolina, once you've already signed and you stated that you're guilty, you could go, you can ask your attorney about it, and perhaps you can tell your attorney that you want to speak to the judge about it personally. He's going to be upset, but you have absolutely nothing to lose. Judges say denied all the time. But I would strongly suggest talking with your attorney about it, about your feelings, anytime and you have an attorney. Don't be afraid to talk about your pleas. That's what they're there for. They can never make you take a plea. And if you think that there's something where you're innocent and now you want to change your mind, once you make that plea, once you sign that dotted line, in most cases it's going to be too late.
I mean, I would imagine, and I don't practice criminal law, but I would imagine that if you were coerced and you can show that you were coerced into signing something that you wouldn't have otherwise signed, and that would be hard to do. That might be one exception. The other thing is you brought something up, and when I did practice criminal early in my career, Johnny, there's something you said that I think our viewers really need to know, and that is you don't have to, it's your decision as to what deal or what plea you enter into. You shouldn't let a lawyer twist your arm into doing something you don't want to do, correct?
Exactly. A lot of times when I meet with my client and they retain me at that particular point and I've received a discovery, and I ask my client, I'll say, hey, what are you looking to get out of this case? I ask that because I want to know what their expectation is. I've heard things as, hey, just keep me out of jail as long as you can. That's always the easy one. I can keep you out as long as you want, as long as you know you're going at some point. But if you don't have a record, you've never been charged with anything, you may say, I want probation. And when you say, hey, I want probation for this, I, at that particular point in time, would say, hey, we're looking at your record, looking at everything that's going on here that's likely or that's not likely. So always discuss what you want out of the case with your attorney so he can tell you if at that particular point in time whether it's reasonable or not, and what is reasonable, looking at exactly the facts of the case and exactly what happened and your record. These are the things that you really want to talk about so you're not hit with, hey, you're going to jail for 5 years or whether you want probation. Tell them what you want and ask them, can it get you there? If not reasonably, what can you expect?
How important, Johnny, is it for a client to be straight up with you and tell you the truth as to exactly what happened? And how does the attorney-client privilege play in that type of conversation or relationship?
Well, it goes like this. Whatever information you give your attorney is what he has to work with. If you choose to lie to your attorney, that's all he has to work with. A lot of times, and unfortunately, people think that they need to lie to their attorney. And a wise attorney will go and look at all the circumstances and try to make a determination of what's going on. Because if you just meet somebody for the first time, you might not feel comfortable with letting them know everything. However, it's to your best. It would be to your best to let him know exactly what's going on. Because if you don't, and something comes up later, and hopefully it's not at trial, that could be your liberty interest. Your lawyer may be able to tell you, hey, based off the fact of what you just told me, there's no way that we can win this case. It's about a 99% chance we may lose this case. We need to look for a plea because he knows the truth. Now, if you go in line saying, no, I didn't do it, I wasn't there, comes out at trial, and your lawyer didn't see it coming, judge says, hey, you're going to prison. Can't blame him.
Yeah, I mean, it's always good. It's always good.
But I will say, as a criminal defense attorney, I hate it, but we hear it, but we don't believe everything that we hear all the time because everybody kind of fudges a little bit, and we kind of expect the lie. But if you are going to tell a lie, tell a good one.
I love it. What's interesting is, yeah, you don't want any curveballs thrown at you at trial. And I always tell our clients, be upfront with me. Good news, bad news, good information, bad information. Be a straight shooter with me, and I'll always be a straight shooter with you, and we'll deal with the facts. I can't deal with something that I can't plan for. or it becomes a lot more challenging. And what's interesting is we've been going for about 25 minutes, Johnny, and I appreciate it. I want to
Already?
leave this. That went fast, didn't it? But I want to leave this conversation with a thought. And if you haven't seen it, I want to send the link over to you. But well-known criminal defense attorney Tom Mesereau, who's defended Michael Jackson, Robert Blake, awesome lawyer, was speaking to a group of high school students in Chicago. And one of the students, in fact, one of the teachers, one of the professors asked if Mr. Mesereau could represent somebody who admitted to him that they had done a terrible, terrible crime. And Mr. Mesereau, as a criminal defense attorney, did not beat around the bush. He looked that professor in the eye and said, "You're damn right I would. That's my job. My job is to make sure that my client's constitutional rights are protected. My job is to make sure the prosecution does what they're supposed to do under our United States Constitution. And I'm proud to be the person to keep that check and balance into our system." In other words, he didn't hedge around that question like I've heard a lot of lawyers hedge around. Oh, I would never represent somebody who I knew was guilty. Mesereau took the other side of the coin. It was a beautiful Q&A over about 45 minutes. Have you seen that video? And if not, I'll send it over to you.
Oh, please do. Please do.
Yeah, I mean, just what an amazing career. He's a very approachable guy. And from a criminal defense standpoint, he's been there and done that for 30, 40 years. Just an amazing track record. And you know what, Johnny? I can't wait, and I probably won't be around in 40 years, but I can't wait to see your career when it's all said and done. You're an amazing young man. You're an amazing criminal defense attorney from North Carolina. I really have enjoyed getting to know you over the past year and connecting with you on social. And can't wait to connect at one of the upcoming Bar Association meetings, conventions, whatever happens. Wherever destiny takes the two of us. And Johnny, if somebody wants to reach out, has a follow-up question, because this show is recorded and we're going to get a lot of traction out of this show, what's the best way for them to reach out and connect with you? If you could remind everybody once again, for those people that tuned in late.
That's Twitter. I'm Cool Relax, COOLRELAXED. Also on Facebook, Johnnie Finch, my name. And then for the firm site is GuntherLaw.com, GUNTHERLAW.com. I'm also on Instagram, Cool Relax. I'm not hard to find. Just ask Mitch.
Fantastic. Yeah, just, and if you guys have a challenge with tracking Johnny down, if he's in court and you can't get him on the phone, get a hold of me. I'll track him down and we'll make it happen. Johnny, it's been a pleasure having you on the show today. Everyone watching the live show and our recorded version of the show, if you have a legal question, if you want to reach out, go to myvideolawyer.com, submit your question, watch past episodes, connect with future episodes. This is a great way, and you can't beat the cost. It's free to get your legal questions answered. And that's why Johnny and I and some of my other friends are going to be doing this, because we really want to help the consumer. That's what it comes down to. Johnny, thanks for being on the show. Enjoy this weekend, and I'll talk to you soon. Okay, my friend?
Yes, sir.
All right. Bye-bye, everybody. Thanks.
All right. Make today.